In the autumn of 2019, I began a blog. It was entitled Statum Fini. And I started it specifically with an understanding that the history of the Republican Party was one of direct confrontation with and repudiation of slavery within the United States. And that recent events, especially when I say recently, I say since the Kennedy Nixon debates, have really put the Republican Party in a positioning that I think is absolutely contrary to its inception. But in a similar manner, something has happened with the Democratic Party, where the Democratic Party at this in this particular kind of juncture has also been portrayed as having or espousing a kind of political praxis. It actually does not and has not since its inception. I now have a greater understanding of the manners in which that occurred and who and what identified the political utility of such a thing occurring. This is part of why I started the blog. That and an understanding that there was a pending peril happening in Texas that unfortunately has come to bear. On the other hand, around this time, I composed a report. It was a follow up to a report that I had sent to the House Financial Services and Senate Banking Committees in March of 2016. I had written an article, I had it publicly published. It was specifically regarding allegations of impropriety committed by the then Secretary of State Hillary Clinton and questioning deals that had been concocted prior to her becoming Secretary of State, specifically while she was First Lady, in connection with Honduras, and how that engaged with and interfered with various policies going on in Honduras regarding indigenous and other kinds of leadership development. This was published in a public realm. There were at least two references to it that I had, and at a certain time, after there was a need to acknowledge other factors that were coming up in relation to that article, I forwarded it to the House Financial Services and Senate Banking Committee with a direct urging that they immediately engage in investigation of the matters that were put into that report. Specifically, or rather, the public reporting, specifically at the understanding that there were people in another country with whom I felt a political affinity, regardless of whether or not I supported them politically, but understood they had a just cause claim. And that as somebody in the United States, it was our duty and our right to challenge who purported themselves to be representatives of us to actually investigate and follow through. Now, I have no indication at this point that that's what happened. On the contrary, what I think happened was a continuation of an ongoing process of political reprisal against me personally and against other people with whom I was affiliated politically. Some of whom, in the last 10 to 15 years, may have determined for whatever reason it was more politically expedient to alter their alliances and allow themselves to be positioned in a strategic arrangement with other political actors. Nonetheless, I contend that the charges that I originally presented to them held merit. In the ensuing time frame, other things became clear. And so I composed a follow-up report and I began it on October 28th of 2019. I had finished what I considered to be a final version and I published it on my blog on October 30th of 2019. I'm going to read it and I'm going to read it in sections. It's currently 3:31 p.m. on July 13th, 2021. It's called Time and Temperance, a Non-Derivative Detraction of the USMCA. The following is a follow-up to a report published in the public realm that I sent to members of the House Financial Services Committee and Senate Banking Committee in March of 2016. I sent it with a request that they formally investigate activities related to former Secretary of State Hillary Clinton's role in Honduras. I've yet to hear back from them, but I've persisted in my own investigation. Consider at your own risk this time. By Charity Colleen Krause, October 30th, 2019. Lanny Davis's exotic dance continues. Not much heed was paid to the fact that an attorney with substantial connections to the Clinton presidential administration was representing a lawyer for the current Trump presidential administration when Michael Cohen testified before Congress. Not much heed was paid either to the fact that prepared remarks, such as those provided by Cohen, had to be submitted to Congress before the hearing to be approved. There was, however, significant attention paid to the details of Cohen's prepared remarks. Included in these remarks was Cohen's submission as evidence of a check issued from Deutsche Bank. Cohen said he was told to write this check to an exotic dancer alleged to have had a dalliance with Donald J. Trump. The story of Stormy Daniels' payoff from Trump paled in comparison with the payoffs by Deutsche Bank to the Department of Justice over the last few years for numerous allegations of fraud and money laundering, including $14 billion in September of 2016 and $7.2 billion in December of 2016. Since Cohen's appearance before Congress, Deutsche Bank also announced on July 14, 2019, that thousands of workers were to be laid off. On August 22, 2019, Deutsche Bank was required to produce another payoff in the amount of $16 million for allegations that they had hired unqualified family members of alleged oligarchs. Deutsche Bank was additionally targeted by authorities in Germany on November 29, 2018, at the same time that Chicago Alderman Ed Burke was being targeted for allegations of improprieties related to his role in the Chicago pension system, per his years of involvement on the City Council's Pensions Committee. What relationship the two announcements have to each other is a story as compelling, if not more so, than the financial arrangements a president of the United States makes regarding his alleged sexual behavior. That, however, was not the matter before Congress in early 2019. Cohen's choice of Davis in the context of the ongoing allegations against Trump for obstruction of justice, executive overreach, and election interference hearkened to a time for which former affiliates of Davis's had testimony before Congress of their own with which to deal. The Department of Justice investigation into former Secretary of State Hillary Rodham Clinton's emails predated the onset of the Department of Justice investigation into allegations concerning the Trump campaign. That investigation included a time frame during which Clinton was responsible for guiding State Department policy in response to the coup in Honduras. As of the end of October 2019, with much less media coverage and analysis than has been given to the allegations concerning the current president, 38 former staff members of Clinton's State Department have been cited for their roles in the allegations surrounding Clinton's emails. At this time, the results of the investigation are still pending. In addition to serving as an executive of Citibank, Davis was involved with a Central American business organization in which many prominent members of the Honduras business community were active. Camilo Atala, the head of one of Honduras's major banks, Banco Facosa, served as director of the Latin American Economic Council as recently as March of 2016. On April 17, 2014, Banco Facosa acquired all loan, credit, and personal banking accounts in Citibank Honduras. In July of 2015, Banco Facosa acquired all accounts with Citibank in Nicaragua. In the United States, since the Department of Justice investigation into the Trump campaign was engaged, Citibank has been involved with numerous large-scale municipal bond issues that have had telling connections with announcements of migrant caravans that departed Honduras for the U.S.-Mexico border. The announcement on October 12, 2018 that a caravan was setting off preceded a two-day Citibank-sponsored issue of $1.2 billion by the New York Transitional Finance Authority on October 15 through 16, 2018. The two-day issue was followed up with a $230 million refund issue on October 17, 2018. These figures reflect the initial announcement in October of 2018. Subsequent to the issue, NITFO reported other amounts, including $1,217,760,000 in November 2018 and throughout 2019, In the beginning of 2019, the New York Water Authority also declared a $400 million issue for water bonds that correlated with the announcement of a second caravan leaving Honduras for the U.S. Mexico border. Unlike later public reports or reports concurrent to the second caravan that attempted to portray the pronounced increase of people seeking asylum in the U.S. in the face of increased drug related violence in their countries of origin, the initial reports on these caravans specifically included concurrent accounts of being supported in official capacities by the government of Honduras in regards to exit from the country, and Mexico regarding assistance in the process of passing through. A primary contestation regarded what was to be done with the aggregate of humans amassed at the U.S. Mexico border. One may or may not make an additional inference from an $850 million Citibank sponsored municipal bond issue for Chicago, due for settlement on May 1st, 2019. In all three issues, the same Chicago based brokerage was involved. The amount of the May 1st, 2019 issue is significant in regards to Honduras, insofar as Honduras announced in November of 2016 that it was set to issue $850 million in bonds for its primary energy interest at El Cajon Dam via Empresa Nacional de Energía Eléctrica. This initial announcement was not carried out. In April 2017, Honduras announced an issue of $700 million for the El Cajon Dam. Another announcement for $150 million was announced in early 2019. The construction of this dam involves Chicago-based engineering firm Harza Engineering, since renamed after merger. What would Cohen's choice of Davis as an attorney in light of these factors have to do with his role in responding to allegations regarding his client's role in election interference and other charges? In order to understand this and the potential implications, an appropriate characterization of the person bringing the charges must first be provided. It was made public record that when an attorney with Rose Law Firm, Hillary Rodham Clinton, engaged in actions regarding billing records that were later investigated for their potential connections to an investigation of bond issues by Dan Lassiter. Lassiter was known as a prolific bond issuer in Arkansas and elsewhere. Several allegations of both former Arkansas Governor William Jefferson Clinton and Hillary Rodham Clinton were made regarding fraud and other crimes, but to this day, no charge has been prosecuted. Neither has a specific accounting of what sorts of bonds were of concern, the amounts of these bonds, or the terms on these bonds being provided to the public. How many of the bonds issued by Lassiter or others with whom he worked were canceled, refinanced, or reissued is also not publicly available information. It is on the public record, however, that former Governor Bill Clinton approved a $30.2 million bond issue for the Arkansas State Troopers specific to a radio communications system in 1985. Following early investigations, both Hillary and Bill Clinton were subjected to numerous legal proceedings which occurred in several jurisdictions. The rules of court are not what they appear to be, and attorneys must know this, something they do not share with their clients when billing them. Different jurisdictions have not only different rules specific to their jurisdiction, but also often ascribe different numerical references to the same or similar rules. The numerical references are of significant importance in understanding potentially proprietary accounting systems. They also provide reference nodes for indexing in consolidated publications regarding court proceedings in various jurisdictions that can be cross-referenced based on case name or citations of other cases within the case itself. This has the potential to form a sort of currency for attorneys and judges, referenced in various contexts within the affiliated cases, as well as in regards to the clients involved. Insofar as court proceedings can require other sorts of exchanges of currency in order to meet certain surety or bond requirements, as may be required concerning specific laws of a particular jurisdiction, then there are a number of ways that this legal currency can be monetized or accounted in such a manner as to produce possibilities for materialization of financial gain for those who are able to access that economy. By and large, those able to access it are not the clients. When billings include filing fees for submissions of documents that may themselves be numerically indexed by the court, there are potentially any number of opportunities to connect accounts to documentation that is associated with a legal proceeding. As such, any legal proceeding entails substantially more cost as well as potential for gain that is readily or explicitly apparent. Is this perhaps what was actually being focused on regarding the allegations between Hillary Clinton's role at Rose Law Firm and Lassiter? The introduction of an electronic legal filing process adds another layer to these considerations. It is important to contextualize this with an understanding that despite the fact that many jurisdictions had done so earlier, the Supreme Court of the United States did not have an official electronic filing process until the autumn of 2017. While some electronic legal databases, which can include substantial back case laws and filings online, can be accessed remotely, some courthouses also offer on-site electronic legal filing access. There are specific things one can access via membership, which requires official acknowledgement from the court in which one is so qualified. For instance, in order to access the electronic filing systems, including case laws and docket records, that are the official court record, one must receive permission to be acknowledged in order to set up or access an account off-site. At this time, the author has received the same information on electronic filings from 2 states for their federal district court filing process. This is for those attempting to file pro se, while there are other procedures for requesting the court's permission if one is not a member of the specific jurisdictional court system involved. Depending upon the jurisdiction involved, similar rules may be specified for different implementation while others are altogether eliminated. For instance, the federal rules of civil procedure make allowance for derivative actions without clarification of what or how such is specified or effectuated. Following the Enron investigation, several derivative actions were filed. There was also substantial derivative litigation engaged for a 2008 case involving Bristol Myers Squibb. For a novice or one who is not a professional, other rules can also compel question for their implications and potential applications, such as rules on substitution of counsel. Additionally, even the federal rules of civil procedure may reflect different implications depending on their source. As an example, consider that the version of the federal rules of civil procedure available on the current site of the U.S. Congress does not include any process for filing a writ of certiorari, and declare that writs of mandamus are not accepted at all, while designating another process for motion for new trial. This exists despite the fact that the version of the Federal Rules of Civil Procedure identified under citation of federal law does specify, at least in some manner, a process for acknowledging a writ of mandamus. Finally, consider that at least one local federal district court includes rules for impeachment without clarification substantiating its justification for so doing. All of this makes appropriate process through the legal system a very specialized one that in effect compels the ceding of one's exercise of the right to due process to one so credentialed in the specialty. The question then becomes, what qualifies one as such a specialist, and under what authority are the requisite credentials issued? Further, in so issuing these credentials, what and where are the securitizable moments, and who or what has access to these securities? Consider then the client and what records or documents the client must produce for his or her cause under the securitized credential of his or her attorney before the applicable judge or judges, likewise credentialed as specialist. Who then regulates or evaluates the performance of attorneys, insofar as there may be need for verification of their credentials? Who then for judges? Who then regulates or evaluates their connections with the securitized moments, with their client's information or others they engage throughout the legal process? Hillary Clinton's professional experience as an attorney was also one of her many attributes as First Lady, first of the state of Arkansas and then of the United States of America. As First Lady of the United States, she was most well known for her efforts to promote universal health care coverage, which did not succeed legislatively at the time. She was also involved with efforts to address the ongoing discussions around energy, but demonstrated what appeared to some as an about-face, following a private meeting with a consortium of leaders in the energy sector, primarily connected to the gas and oil industry. How much her influence as First Lady influenced the executive actions of the president is speculative, but insofar as Hillary Clinton did not disengage from the strategic partnership she had with Bill Clinton, and she must have been well aware of the potential implications of his executive order, 12866, of September 30th, 1993, Regulatory Planning and Review, which states, quote, the American people deserve a regulatory system that works for them, not against them, and improves the performance of the economy without imposing unacceptable or unreasonable costs on society. Regulatory policies that recognize that the private sector and private markets are the best engine for economic growth. We do not have such a regulatory system today. Now, there is a break between that section and the next section. As I said, there are more than one section, there are three. But I will say, at the time I composed this, I was not aware of the information from the Brookings Institute, which would have had its 7-year anniversary the day after I published this. And one of the things it speaks about specifically and contains is an index regarding rule of law in Afghanistan. I did not know. Nobody told me. But it does fit a trend. It does fit a trend wherein me, personally, and my identity, which I've already United States, it was read into law. This is a verbal recitation, but it has been publicly available for pretty much the entire time frame since it was first published on October 30th of 2019. I appeal to you. Whatever it is that you are considering or contemplating at this point in time, please make your decision publicly and swiftly as soon as possible.